Most people believe a divorce decree is the end of their legal worries. Once that document is signed, they think the hard part is over. Assets divided, custody agreed, and life moves on. But what they don't realize is that buried in those pages are phrases that can quietly strip away your rights as a parent, long after the ink has dried. Imagine discovering, months or even years later, that a single legal term prevents you from choosing your child's school, vetoes your medical decisions, or even blocks you from moving closer to home. Those aren't worst-case scenarios. They're the real consequences of 8 hidden words many parents never spot until it's too late. In the next few minutes, we're going to reveal the 8 legal terms in divorce papers that can permanently limit your parental authority. You'll learn why sole legal custody isn't as straightforward as it sounds, how a non-relocation clause can anchor your child in place, and why an emancipation provision might sever your responsibilities and your rights sooner than you expect. If you're signing papers or helping someone who is, this could be the most important 10 minutes you spend today. Because recognizing these phrases before you agree could mean the difference between staying fully involved in your child's life and watching critical decisions slip out of your hands. Let's dive in. When your divorce decree awards sole legal custody to your ex, it sounds straightforward. One parent makes the big decisions. But in reality, that phrase hands over every critical choice on a silver platter. Where your child goes to school, what doctors they see, even which religion they're raised in. You might assume you still have a voice at the table, but the law is clear. Sole legal custody means you're effectively cut out of all decision-making discussions. Any hope of influencing your child's medical treatment or educational path vanishes unless you petition the court to modify the order. A process that's costly, slow, and far from guaranteed. Worse, many parents don't realize the full impact until they face an urgent situation, a school transfer request or a health emergency, and discover they have no legal standing. Recognizing this term before you sign is crucial, because once you agree to sole legal custody, you've relinquished your right to guide your child's future in ways that no courtroom victory can restore. At first glance, joint legal custody feels like the compromise every parent wants. Shared decision-making, balanced power, fairness. But in practice it can trap you in endless stalemates. Every time a school choice, medical treatment, or major activity comes up, you need your ex's agreement. If you disagree, you're forced back into court or into expensive mediation just to move forward. That means delayed decisions for your child and mounting legal fees for you. And because joint custody orders rarely specify tiebreaker rules, you can be left waiting while your child's needs hang in the balance. Understanding this upfront, and insisting on clear, enforceable protocols, can prevent you from being sidelined in your child's life. But locking in shared custody is only the beginning. What happens when visits themselves become restricted? When your decree specifies supervised visitation, it might sound like a protective measure, but in reality, it can turn every visit into an ordeal. Instead of private time with your child, you're forced to schedule visits through a third party. Often at a facility, with a monitor in the room. No spontaneous park outings. No bedtime stories tucked in under a blanket. Every hug, every word, every tear is observed and recorded. That monitor's report can influence future custody hearings, too. A frown or a misunderstood remark could be framed as inappropriate behavior, giving your ex new grounds to argue for even tighter restrictions. Meanwhile, your child senses the tension. Visits feel clinical, not comforting. What was meant as a temporary safeguard can become a permanent barrier, eroding the natural bond you share. Spotting this term early is essential. If you see supervised visitation on that page, demand clarity on who supervises, where it happens, and what criteria allow you to move back to unsupervised visits. Otherwise, you risk signing away the private, trusting moments that truly define your relationship. And once that phrase is in the decree, it can be a fight to ever get it removed. A non-relocation clause may seem like a simple line preventing you from moving too far away. But in practice, it can feel like your child is anchored to a single address forever. If you decide to pursue a job opportunity in a neighboring city or move closer to family for support, you can be blocked without your ex's explicit, written consent. That consent isn't guaranteed. Disagreements over distance, even as minor as 50 miles, can spark new court battles, dragging you back through mediation or a hearing just to change your child's zip code. Meanwhile, your dream job slips away or the support network you need remains out of reach. Worst of all, the stakes are high. Violating a non-relocation clause, even accidentally, can lead to contempt charges, fines, or loss of custody time. You might think you're negotiating flexibility, but once that phrase is in the decree, It can silently steal your freedom to build a life that works for both you and your child. Recognizing it before you sign is essential, because undoing a relocation restriction can take years. Time you and your child can't afford to lose. In some states, the term custody disappears altogether, replaced by parental responsibility. That sounds modern, until an order assigns full responsibilities to your ex and leaves you with none. You might think you still have rights to time and input, but legally, all daily decisions, from extracurricular activities to emergency medical care, are in their sole hands. This isn't just semantics. A parental responsibility order can bar you from authorizing simple things like a school field trip or reviewing your child's disciplinary record. If a decision needs signing, permission slips, medical consent forms, you're out of luck unless you win a court modification. And each modification requires fresh filings, legal fees, and emotional strain on your child, who watches you scramble for permission. Understanding this shift in terminology is vital before you agree. Ask for precise language that balances responsibilities, or insist on a clause that preserves your right to day-to-day involvement. Otherwise, that seemingly innocent phrase could transform you from a participating parent into an onlooker in your child's life. Seeing termination of parental rights in your decree might feel like the ultimate worst-case scenario, but you'd be surprised how casually it can appear, often bundled into broader language about guardianship or adoption. Once that phrase takes effect, your legal bond with your child is severed completely. You lose every decision-making power, every visitation right, and every claim to parental support. It's not reversible. Courts rarely reinstate rights once they're terminated, even if circumstances change or the other parent's situation shifts dramatically. You're effectively erased from the legal picture. No court orders, no support obligations, no path to reconnection unless a judge makes a very rare exception. Sometimes termination is presented as a solution for complicated custody disputes or as part of a step-parent adoption. But if you don't fully understand the implications, you might agree without realizing you've given up everything. Recognizing and challenging any suggestion of termination up front is crucial, because once you sign off, you're legally treated as though you never existed in your child's life. And no phrase in a divorce decree is more final, or more dangerous, than that. An emancipation provision can lurk in your divorce paperwork, quietly declaring your teenager legally independent long before they reach adulthood. At first, it might sound like granting freedom, recognizing a mature teen's capabilities, but in reality, it strips you of both authority and obligation. Once that clause takes effect, your ex can no longer require child support past the emancipation date, and you lose any legal right to guide your child's education, finances, or medical care. Imagine your 16-year-old signing a lease or making medical decisions without your knowledge, and you powerless to intervene. Emancipation provisions are often buried in broader language about support obligations ending upon the child's emancipation. So if you don't catch it, you could be blindsided when your support payments stop and your parental voice is silenced. Spotting this term before you sign means asking hard questions. What criteria define emancipation? Who makes that call? Can we negotiate a later date? Otherwise, you risk agreeing to sever the bond that keeps you actively involved in your child's life, sometimes years before you're ready. An order of protection or restraining order isn't just about keeping someone away. It can instantly suspend your visitation and decision-making rights the moment it's filed. One phone call to the courthouse, and you could find yourself barred from your child's school, excluded from medical appointments, and cut off from everyday contact without a hearing. In many jurisdictions, these orders take effect immediately to protect the child. But that urgency often leaves the accused parent scrambling to prove their fitness in a separate, lengthy court process. For your ex, a protective order can become a powerful negotiating tool. They might threaten or actually file one to force you back to the table on custody or support issues, knowing you'll pay legal fees just to lift the restriction. Meanwhile, your child endures confusion and distress, caught between fear and longing for their other parent. And because these orders are public record, even a dismissed order can cast a long shadow on your reputation and future custody battles. Catching this clause in your divorce papers is critical. If you see any language about protective orders or restraining provisions, don't gloss over it. Ask how it can be triggered, what evidence is required, and how the process unfolds. Otherwise, you risk giving someone the power to remove you from your child's life with little more than an allegation. And once that phrase is in place, reversing its effects can take months of hearings and filings your family simply can't afford. Looking back over these 8 legal terms, it's clear they're more than just lawyer jargon. They're power switches that can turn your role as a parent on or off. From sole legal custody that cuts you out of every big decision, to a non-relocation clause that anchors your child in place, to an order of protection that can lock you out overnight. Each phrase carries consequences you may never anticipate. Most parents focus on splitting assets and carving out parenting time. But the real fight is over those precise words hidden in your decree. Because once you sign, it's nearly impossible to reclaim authority you unknowingly surrendered. If this video opened your eyes, tell me which term surprised you most, and how you plan to protect yourself. Leave your thoughts in the comments below. Your story could help someone else avoid a devastating mistake. And if you haven't subscribed yet, hit that button now. We'll keep uncovering the critical details lawyers often overlook, so you can stay one step ahead and remain the parent your child needs. Thanks for watching. Stay vigilant, stay informed, and remember, understanding the fine print means keeping your rights and your child's future in your hands.